Okay.
This was the letter seeking to have an agreement that the department and the patient advocacy groups would jointly approach a court for an appointment of curator to look after the patient's rights. And you said you had not received this letter. You said,
No.
What did you say? You had received the letter.
No, I said I did not. And I did explain that, Council, that not every correspondence addressed to any politician will get in to be seen or to be read or whatever. So I would have said that. I don't exactly remember the words I used before lunch.
Did you receive the letter?
I said a letter addressed to me may not necessarily be seen by me in person, or if I had seen it, probably it will be sent to the relevant people. As you've seen, it is addressed to a number of people, but I'm aware that the HOD would have dealt with some of the issues that are raised there, which I had seen those issues after in 2016.
Did you say that you hadn't read the letter until after?
I did indicate earlier that the HOD did indicate to me that they went to court and because there were issues that they were differing with the Section 27 and
yes,
the outcome of the court processes.
And it was only after the court proceedings that you read this letter?
No, I didn't read the letter. We spoke to the HOD in passing on related to the issues that they were in court about.
So the letter is sent from Ms. Umnyana Rujeje, and it's sent to your email address, and it's sent to a one Kanyisa Nkuna. Who is that?
It was my personal assistant at the
your
time.
Your PA?
Yes.
And so when it arrived in your inbox and with your PA, did you not read it?
Through you, Justice, people who work in my office had one or two, I can't remember exactly the other one, they had access to my email to check, particularly for work-related issues. Some emails I would read them personally, some of them I would not read them personally. So and I would like to repeat, Justice, through you, not every correspondence that is sent to every politician get to be seen, to be read, and to be attended to by a politician specifically, including in this instance.
Correspondence that's threatening litigation, would that not be read by you?
The correspondence threatening litigation in the Department of Health, it happens every single day. So the HOD deal with those matters, and he's competent authority to deal with those matters. If he sees that the matters requires him to consult the MEC about the specificities of that matter, he will definitely, in some instances, he would have come to me and say, on this and that matter, what do you think, and then all of that.
So this was an unusual matter, though, isn't it? Wasn't this a matter in which there had been a lot of media already? There were a lot of attempts to reach you by patient advocacy groups. There were concerns that had been raised by health professionals.
At the time, Council, I did not see anything unusual about me and the HOD discussing nitty-gritties of the operational matters related to the department every day.
But this wasn't nitty-gritty. This was about a decision that you took.
But Council, the Department of Health, or any department I've been to, takes number of decisions on every single day or every month or every week. And not all those matters through you get to be dealt with in their conclusion with the involvement of the executing authority. Many of them will be concluded without even the knowledge of the executing authority, because the HODs are competent in terms of the law, and their powers is derived from legislation. It's not the delegated functions.
In other words, if the public writes to you, there should be no expectation that you will actually read the letter.
Through you, Justice Moseneke, at all material times, to the extent that I could and to the extent that I tried, I dealt with all the matters that were brought to my attention, whether
Yeah.
via SMS or via email. And I think that suffices to say that.
But you
if there were
didn't deal
issues that
with
were-
this letter.
I
that
may
was
not have
brought-
dealt with them personally, but the head of department dealt with that issue, and I think he's competent enough he was competent enough to have dealt with those issues
I think you're
himself.
bound by the answer at this point, Council. You have asked the question many times, and the answers come back. I don't remember whether I read the letter or not. So we have to proceed.
Thank you, Justice. So the steps that took place then subsequent to this letter was that lawyers for the department responded to the letter. And in the same file that is in front of you, if you have a look at page 189, these are letters from your attorneys, isn't that so?
Yes, it is.
It's the same attorney that you sent an email to regarding the dishonest NGOs, isn't that so?
Yes, I copied him in the email.
And this is the same attorneys on page 189.
Yes, they were working with duly contracted by the department.
And in the first paragraph of that letter, that response, the attorneys say, we represent the Department of Health, MEC, Qedani Mahlangu, Dr. Barney Salabano, and Dr. Manamela in the matter. And do you see that he represents you, amongst others? And then he says, if you turn over the page to paragraph 5, well, the first thing he says is, our clients have taken all reasonable steps and in keeping with the various legislative prescripts of the Act to effectively provide both for the discharge and the transfer of the users. Any allegation to the contrary is either self-serving or disingenuous. Did you instruct your attorneys to respond in this manner?
Through you, Justice, I said before lunch, and I'd like to set it on record again, correspondence is, or when people have litigation against the Department of Health, since I've been an MEC for Health in 2009, and I've till 2010, and now in 2012 till I left in 2017. In many documents relating to litigation, the MEC for Health is always cited as a first respondent as to what is the origins of that. I did not go into detail to research the origins of that. As I made an example earlier, if when a woman gives birth in a particular hospital, something goes wrong, the baby dies or a mother dies, and that's when the family concerned sues the department, they do not sue the doctor concerned, they sue the Department of Health. And the first respondent in those documents is the MEC for Health. I'm sure the legal department of the legal representative of the department can share that information with yourself.
You were the first respondent, and that's because you took a decision to terminate the contract. Do you not think you were cited because of your responsibilities under Section 125 of the Constitution?
My responsibilities as defined in the Constitution and in all other legislation, I guess it requires that the MEC for Health or MEC of any department be cited. If a policeman shoots a person somewhere, the person who gets...
I'm sorry, allow me to interrupt you.
Sorry.
You know, the answer could have been... We've been at it for 2 days now. We have to come to an end sometime. Please listen to the question. Frankly, the question is whether you personally instructed these lawyers to write about you or not. It may be that your head of department included you in the defense because you are cited. But let's stay with it, because I really am anxious that we should move on. The question is, did you instruct these attorneys personally to write about you?
I did not.
I
was giving a context.
Yes, and let counsel come back and say what they say.
Thank you, Justice.
But for now, you did not instruct them personally, or you did.
No, I did not.
You did not.
Yes.
Very well. Counsel.
And do you say that this letter wasn't provided to you before it was sent either?
No, it wasn't.
So the importance of the letter, apart from the fact that it says that they represent you, is that the instructions that the attorneys were given was that all steps were taken, all reasonable steps, to effectively provide for the discharge of users, and that our clients, meaning the Department of Health, in which the attorneys include you, have consulted all the health services to which users have either been discharged or transferred to. And then they go on to say that the insistence of the NGOs, that is of SADAG and SASOP and so on the suspension of the discharges is a reckless and a demonstration of selective morality. The first thing is that that tone appears to be very similar to the tone of your email where you call the NGOs dishonest.
But Council, I think you're really being unfair. For every word that is written in the letters or correspondence with the Department of Health, we are going to attribute that I'm responsible for
I'm
those.
asking you before
But
I
it's
can
incorrect.
attribute it.
It's
So
incorrect.
It's not similar tone to your,
It cannot
email.
be. It cannot be. And I did explain the context to why the tone of that of that message. And again, I'd like to come back to you, Justice, because it looks like
You are well protected. Your answer is the tone is not the same as the one in the email. I think that's the answer. I'm going to ask you to stick to the question. There are moments when context will help us, but it's not helpful all the time.
okay.
So you're very well, I don't want to restrict it to yes, no. As you've seen, I've been very patient. But at the same time, there are facts that counsel would like to raise or doubts in your testimony, and they're entitled to do so within reasonable limits. They also have limits, and you have to give answers and within reasonable limits. So let's go. The proposition is that, or the accusation is that, the tone of this letter is the same as the tone of your email. You can say no, it's the same or not the same.
But I didn't write the letter, Justice, so I can't really have, there's no relationship between the two things because I did not say to the lawyer and say, write this. If I did, indeed, I could say, I could easily answer the answer.
Sure, it's a fair answer.
And
you write the letter, therefore the tones can be the same. That's the answer. Counsel.
And the statement by the lawyers that all of the health services had been consulted, which would include the NGOs, before the transfer took place, before transfer was to take place, we know now was actually not true. Isn't that so?
But Counsel, remember, attorneys are briefed by officials of the department. And whatever information you brief the attorney, if you give the attorney the information that's wrong, they'll come to wrong conclusion. If you give the attorney right information, they'll come to that conclusion. So I think it would have been best to have raised this matter with Dr. Silibano himself.
So you're saying that Dr. Silibano and or Dr. Manamela instructed the attorneys to say this?
Yes, because that's an administrative process that they were busy with and engaging in.
And did you not give an instruction? Well, let me say, you've said already that you gave no instructions in relation to this litigation. At page 398 of the same file,
Okay, I'm there.
it's a notice of intention to oppose, and it's filed on behalf of, apart from the HOD and the Premier, it's filed on behalf of you, the first respondent. It says, that the first respondent, amongst others, hereby gives notice of intention to oppose. You did not give that instruction to
I think
oppose.
my first answer I gave about the MEC for Health being a first respondent on many legal matters suffice, Justice.
So the process would be that you just cited for some reason, but any instruction that...
Through you, Justice, if I can just try and assist, perhaps we may put this matter to bed. The witness has testified on many occasions that she will normally be cited in any litigation against the department. And that matter is regulated by the State Liability Act, which requires that the executive member should be cited in every litigation. So, to the extent that the witness has testified that the administrative decisions relating to litigation were taken by the head of department, the witness cannot take the matter any further in response to issues relating to the litigation. So that matter about the citation, because she's now being cross-examined on why a notice has been given on her behalf as the first respondent. Indeed, it is correct. The citation will include the member of the Executive Council as required by law. Thank you.
Sure. Counsel.
Justice, it's not as simple as that, because while there are legislative prescripts that require the political principle to be cited, there are other reasons why a political principle is cited. And the mere fact that the HOD and others are cited doesn't mean steps can be taken in the name of the MEC without the MEC giving an instruction. Secondly, the MEC was cited because of her particular responsibilities. The political principle, merely by being a politician, doesn't evade constitutional accountability. It's not, and if the answer of the witness is that the political principle has no role in litigation, things will be filed on their behalf and they're not asked and they give no instruction, that's a cause for concern, but then we'll leave it at that if that's going to be the answer.
The response, I think, is more nuanced. It is, I'm a state functionary, I get cited ordinarily, often, all the time, but I did not give actual instructions. The Premier cited, he'll probably say the same thing. He asked the questions. I did not give actual instructions. What your argument will be later, a different matter. She should have taken active interest. That's a fair argument. But for cross-examination, the answer is, I did not instruct personally. And you can invite me to make inferences from that later.
Thank you, Justice. The culmination of this stage of litigation was that it resulted in a settlement agreement. Was that settlement agreement brought to your attention?
Yes, the HOD informed me. I think it was in January 2016. Yes.
And are you familiar with the terms of that agreement?
Not all of it. And noting that I did say in the morning through you, Justice, that beginning of 2016, I wasn't too well. And I ended up being hospitalized. So the nitty-gritties of exactly the contents of the settlement, he mentioned that there was a settlement and by agreement of the two parties. Thank you.
And that was all you were informed of, as far as this litigation goes?
That they were implementing the decisions of the court, of that agreement between the two parties.
And do you know now that, in fact, that didn't take place, that the department breached the settlement agreement?
Can you please repeat the question?
Do you know now that the department breached the settlement agreement?
Well, post the conclusion of the placement of the NGO, that's how I came to understand that.
And as a result of that, the transfer of mental health care users continued. And that was December 2015, January 2016, which then led to your own officials raising concerns. So let's go to that. So we were talking about stakeholders, patient advocacy groups, and the general public. Nothing came of their concerns. The process went ahead. And then on 12 February 2016, Mr. Mosonogi writes to you, and you've alluded to the letter earlier, and it's in Ella 2, Annexure 5, page 27.
This one? No, I don't have. Let me put it down.
Thank you.
So two. Yeah, they'll direct you to your pen.
Okay, thank you. Which page, madam?
Page 27. It's an email. Do you see it?
On the 11th of February.
12 February 2016, an email from Mr. Mosonogi to you.
And I don't have it. I can't see it here, but
I don't see it either. Ella 5, is it?
Ella 2, Annexure 5.
Ella 2, Annexure 5. And then let's try again. Ella 2, Annexure 5. You must have found it now, have you?
I see Annex 6A, and
I've got it.
90.
Have you
Annex
found
4 and
Ella 2?
and Annex 4B, but I can't find. There's 24, 25 pages, 26, 29. I don't have 27, 28. But I don't have this one. Okay, that's fine. Yeah, I've got access to it.
Do you have it now?
Yes.
Is this the email that you were referring to earlier?
Yes, that's the email I was referring to.
And this is an email in which Mr. Mosonogi raises his concerns, and you've read it.
I read it now after Advocate Nguchane shared it with me. Last week, Thursday.
So we've been through this letter several times as well in the hearing. And it's an appeal again to you to take a different course with regard to this project. Do you agree?
I agree with what the contents of the letter said. May I again, Justice, bring it to attention during the time, this is the time when I was recovering at home. I was on sick leave during this time, and if you care to want to know the details, my file at George Mukari is available. My file is at Qedani Mahlangu is available.
I believe you are
Yes,
unwell, but I
so-
want to know, did you receive the letter?
I did not receive it, and I did not go do any work-related stuff when I was not well. And I don't remember seeing it till Advocate Nguchane shared it with me last week when he was briefing me.
So the letter from Mr. Mosonogi, which raised all these concerns interdepartmentally, never reached you?
I don't remember seeing it, Justice.
I don't remember it's a safe base, but do you deny that you received it?
I don't remember, Justice. Remember, during the time I was at home, I wasn't well. And it's either my email was opened by someone who referred the matter to the HOD.
Counsel,
So you didn't receive this and you didn't read it?
I was not well. I was
That's
recovering
fine.
from home. If you really would, you care to want to get my files, they are open.
No.
We can have access to them.
I just want to know what happened to the letter. Attached to the email is a proposal, and the proposal is from all of the senior managers in your department.
Just maybe to answer the question specifically on the contents of this, I remember in the issues being raised in a meeting, not in the email.
But look at the email. Will I be referred to the email where it
Yes.
starts, we therefore senior managers tasked to implement. Can you see that part?
Yes, I see it.
Yes. So council has questions to you about that. Would you proceed, council?
Thank you, Justice. So the three, this is the alternative proposal. As I said, it comes from all of your senior management team. There are three aspects to the proposal. The first is, they say, let the department extend the process by at least a financial year, in summary. 2, they suggest that you begin the negotiation to take over Life Esidemini. And then 3, they say over the course of the year, commencing March 2016, a smooth, deliberate process be undertaken. And they go into detail. And they ask you to consider this proposal. And they say it was discussed and shared amongst them.
Again, Justice, I do not remember the email, and I do not remember seeing it. And during this time, it's a time when I was recovering and I was not at work. Secondly, the contents, for instance, what exactly is the contents I want to talk about? Firstly, the first issue was about banning, that we shouldn't cancel the contracted banning. We agree, there was no argument from anyone that banning should not be cancelled. Instead, the officials must negotiate with Life about the continuation of banning till a solution is found.
How did that proposal reach you?
It was presented in the meeting by Musenochi and the team. Secondly, the second issue being raised was that there should be extension of the cancellation. Instead of ending on the 31st of March, it should be either 6 months or 3 months, as discussed. We then, after discussion, agreed that we will extend it by a period of 3 months. Instead of ending it on the 31st of March, the contract will be extended up until they will be ended at the 30th of June.
And on the suggestion that you look at procuring Life